Straight ahead on Law and Crime Daily.
What do we want? Justice! When do we want it? Now!
Jury selection begins in the trial for the death of Ahmaud Arbery, and convicted murderer Robert Durst hospitalized with COVID-19.
He's going to appeal the conviction, but I don't know that he's going to last another 6 months.
Plus, could Kobe Bryant's widow be subjected to a psychiatric exam? Why Los Angeles County asked Vanessa Bryant be evaluated. And later, a Kenosha shooting victim takes legal action, saying emergency responders condone violent white nationalist acts. Law and Crime Daily covering court cases from coast to coast. Welcome everyone to Law and Crime Daily. I'm Brian Buckmeyer along with Terry Austin. Nearly 2 years after the shooting death of Ahmaud Arbery, the trial against his accused killers begins with jury selection. In what's expected to be a weeks-long trial, jury selection began Monday with defense and prosecution going head-to-head about questions for potential jurors. All this as 3 Georgia men face charges of malice murder, felony murder, and other related charges in the death of 25-year-old black man Ahmaud Arbery. In February 2020, Arbery was shot and killed while jogging near his Brunswick, Georgia home. He was unarmed at the time of his death. Father and son duo Gregory and Travis McMichael tailed Arbery in a pickup truck before Travis McMichael shot and killed him. The pair claimed self-defense and used a Georgia citizen's arrest law that has since been repealed and replaced. The McMichael's neighbor, William Bryan, followed along in his truck, capturing the entire incident on his cell phone. The shooting created national outrage after that cell phone video went viral in May of last year. After that, Gregory and Travis McMichael were arrested, followed by Bryan's arrest 2 weeks later. All 3 men have pled not guilty to the charges. On Monday, prosecution and defense attorneys addressed the racial uproar the shooting created and how it will affect jury selection.
In the beginning, the vast majority of media coverage characterized the defendants as white, racist murderers who saw Ahmaud Arbery in their white neighborhood out for a Sunday jog, and so they got in their truck with guns, chased, trapped, and executed him. In fact, those are the exact words that the state used in the preliminary hearing in June 2020.
Do you agree with the statement? This case has been important in revealing the racism in our community. Well, what has that got to do with the guilt or innocence of these defendants, about the aftermath of this case and everything that took place? Asking the jurors, do you believe this makes this person a racist? Do you believe this makes this person a racist? So there's a propounding of a number of questions where they want the juror to say, I guess, that, oh yeah, if somebody does this, I automatically think they're a racist. Those sorts of questions I think are inappropriate, especially for voir dire. Number 23, white people who use the N-word are racist. Getting them to agree or disagree with that statement.
Inside the courtroom focus on the legality of racial tensions within the trial, race also weighs heavily on the minds of Georgia residents. Over the weekend, dozens took to the streets rallying together for justice in the death of Ahmaud Arbery. This video, taken by Law and Crime Network supervising producer Stephen Lawrence, shows the peaceful protest calling for change. For gavel-to-gavel coverage of the trial, follow Law and Crime Network for live updates, and for the latest trial news day by day, stay tuned to Law and Crime Daily. Joining us today is legal analyst Sue Ann Robinson and Terry Austin. Sue Ann, 60 jurors were reported to court after 1,000 questionnaires went out to the community. Is this a lot, or does it make sense for a trial like this?
Well, you know what they say, the bigger the better. And I think in this case, the idea was the bigger the jury pool, the better chances there is of finding an unbiased, fair jury in this case. I think when you have a high-profile, community polarizing case where a high-ranking official involved in the case has been indicted, you have to really expand the pool in order to find people who exposure to the case has not affected their ability to look at the facts impartially. And I think that's what they're trying to do.
Makes a lot of sense, and we'll see if that actually works out. Terry, we can see what's being discussed outside the courtroom. What issues do you think will be discussed in this jury selection?
Well, inside the courtroom, the judge is going over the voir dire questions. He made some procedural issues, and he determined those issues. So, for instance, he said he himself would not read the indictment. That is for the state to do. He also made sure that he gave out the right number of strikes. There's 9 total. He split those up between the defendants and gave them extra. So at the end of the day, each of them will now have 8. And he also gave the state some extra strikes. But he made some substantive issues too, Brian. He did say that a question about the Confederate flag could come in. He also said that there would not be any discussion about political issues like the name of the prior DAs. That wasn't relevant, he said.
All right, seems like the judge is running a tight ship. Let's see how that continues as we continue to follow the Ahmaud Arbery trial. Thank you both. On to Brian laundry news now. This week marks 1 month since the manhunt began for the wanted fugitive. Many questions are still unanswered as officials continue to survey the Florida preserve where Laundry's parents said he went hiking. In early September, Laundry returned home from a cross-country road trip without fiancée Gabby Petito. He was staying with his parents at their Northport, Florida home when he told them he was going hiking in a nearby reserve. Laundry left without a cell phone or wallet. Gabby Petito was reported missing days earlier. On September 11th, her remains were found in Wyoming on September 19th. Her death was ruled a homicide by strangulation. A warrant for Laundry's arrest was issued in late September, citing unauthorized use of a debit card. And in Florida, a man accused of killing his wife, 3 children, and the family dog appears in court ahead of his upcoming trial. Anthony Toti was arrested in January 2020 when the bodies of his wife, children, and dog were found in the family home after missing for weeks. Toti's children range from age 13 to just 4 years old. He originally took responsibility for the murders, but later blamed his wife. A trial was set to begin on September 27th, but prosecutors wanted to delay the start to sift through large amounts of evidence. The trial is now set to begin on November 1st. Toti is pleading not guilty to 4 counts of first-degree murder and 1 count of animal cruelty. Still ahead on Law&Crime Daily, wife of late Kobe Bryant to appear in court, while Los Angeles County says Vanessa Bryant needs to undergo psychiatric evaluation. But first, Robert Durst is back in the hospital, this time with a COVID diagnosis. What next for the real estate heir turned convicted killer? It was the video that shocked the nation. An unarmed black jogger, 25-year-old Ahmaud Arbery, gunned down in broad daylight.
We are going to make sure that we find justice in this case.
The 3 men charged will now stand trial.
I told him stop till he hit me. I had nothing to do. There's nothing else I can do.
Well, you're a passerby coming through?
Nah, not necessarily.
That's my son that shot him. I was at the back of the truck.
Starting October 18th, watch live gavel-to-gavel coverage on the Law&Crime Network. Welcome back. Days after Robert Durst gets a life sentence for the murder of his best friend, he's hospitalized with COVID-19. Law&Crime's Anjanette Levy is here with what this could mean for Durst's conviction, and a report on a grand jury is hearing evidence against him in New York. Anjanette?
Brian, Robert Durst's lawyer, Dick DeGuerin, says that Durst will appeal his conviction for Susan Berman's murder. However, he doesn't know if Durst will actually live that long. His health was already failing before the trial started.
When Robert Durst appeared in court for sentencing last week, it looked like he was having trouble breathing. The following day, he was admitted to the hospital for COVID-19 and placed on a ventilator, according to his lawyer.
I hadn't seen him in a couple of weeks, and he had looked even worse yesterday than the last time I saw him.
That was Dick DeGuerin last Friday in his first TV interview since the trial, talking about Durst's health deteriorating. That day, Durst was taken to the hospital. His hospitalization comes as News 12 reports the district attorney in Westchester County is presenting evidence to a grand jury in the disappearance of Durst's first wife, Kathy McCormick Durst. Robert Durst has long denied having anything to do with Kathy's disappearance. Her body has never been found. But Durst has been suspected of killing Kathy for years.
However, in telling where Kathy is, perhaps you can find some small redemption in an act of humanity.
Susan Berman's godson, Sarab Kaufman, made a plea to Robert Durst during the sentencing.
I hope in your final days and hours you will come to the same understanding and give the McCormicks what little they are asking for, to find Kathy, to lay her to rest appropriately, finally, and at long last.
Meanwhile, Dick DeGuerin says he's seen the same reports about the grand jury, but hasn't spoken with the prosecutor in New York.
Frankly, if there is a fair grand jury presentation made in Westchester, there will be no indictment because there's no evidence.
Now, if Robert Durst dies before his appeal is exhausted, his conviction in Susan Berman's murder would be vacated, meaning it's as if it never happened at all. A Westchester County DA's office spokesperson would not comment on the reports that a grand jury is hearing evidence currently against Robert Durst. Brian?
Thanks, Anjanette. Back to discuss the health and future of Robert Durst is legal analysts Sue Ann Robinson and Terry Austin. Terry, what do you think is in store for Durst, sick with COVID, post-sentencing?
You know, I think first and foremost, we hope that he does get the medical treatment that he needs. He is or was in a correctional facility in Los Angeles. Presumably, he's back in the same hospital where he was previously hospitalized when he got sick once before. You know, the HIPAA laws prevent them from telling us anything too specific. But as Anjanette said, DeGuerin already confirmed that he has been hospitalized and that he is on a ventilator. So he's 78 years old, Brian. We know that he has bladder cancer and many other ailments. So hopefully he will survive post-sentencing, and hopefully the Westchester County will be able to bring an indictment or whatever else happens up in Westchester.
I mean, Sue, speaking of Westchester, will this affect the West Area grand jury? Will they still push forward if Durst could possibly die?
I think they will still push forward until it's apparent or certain that, you know, he's no longer living. I think this is a case where justice delayed is absolutely possibly about to become justice denied if Robert Durst passes away before he's able to be indicted by the Westchester grand jury or certainly be sentenced. So it's just an unfortunate situation where Robert Durst is, you know, being brought to justice at such a late stage in his life as a septuagenarian. That's extremely unhealthy, as opposed to years ago when he was first tried for these cases that the state attorney in Susan Berman's case said they were going to prove 3 crimes. And apparently the jury agreed that he did. So I understand the McCormick's position. Listen, if Susan's death was proven, it was to cover up that he killed his wife. So it's just a tough situation where he's a septuagenarian, his health is failing, and time is running out.
Absolutely. Now, Anjanette, what are Kathy Durst's family members and their lawyers saying about the grand jury reports and Durst's diagnosis?
Well, Brian, you know, I emailed Kathy McCormick's brother last week, and he put me in touch with his lawyers, and they really said they could not comment at this time. And then I emailed them again about this COVID-19 diagnosis, and they did not respond to that email. Obviously, this is something, you know, the family has been waiting for almost 40 years now. They've believed for decades that Robert Durst killed Kathy Durst. So they've been waiting for a grand jury investigation and an indictment. So we can only assume that they are watching this whole process unfold very closely.
Yeah, we'll see how that process unfolds. And when we get an update, we'll be sure to bring it to you. Coming up on Law and Crime Daily, the surviving victim of the Kenosha unrest says law enforcement officers enabled the deadly shootings. Plus, Los Angeles County demands a psychiatric evaluation for Kobe Bryant's widow, why she may have to undergo evaluation for an upcoming lawsuit. Welcome back to Law and Crime Daily. Los Angeles County is calling for Vanessa Bryant to undergo a psychiatric exam before her lawsuit can go to trial. This comes nearly 2 years after beloved NBA legend Kobe Bryant tragically died in a helicopter crash in January of 2020. Their 13-year-old daughter Gianna also died, along with 7 other passengers. After that, Bryant's widow Vanessa filed a lawsuit against LA County for invasion of privacy and negligence, arguing the county employees improperly shared photos of human remains at the site of the crash. According to the documents, the lawsuit stems from claims of severe emotional distress due to the release of the photos. The county maintains that employees did nothing wrong, arguing that Vanessa Bryant suffered emotional distress from the crash itself rather than the photos that were shared of the remains. County officials argue the plaintiffs must prove they are suffering from ongoing depression, anxiety, and severe emotional distress. They say that they must be done through a psychiatric evaluation. Right now, the case is scheduled for trial in February 2022. Let's bring back legal analyst Sue Ann Robinson and co-host Terry Austin. Terry, making the victims take an exam, is that typical of these types of cases?
Brian, it's not unusual in a civil lawsuit to make the plaintiff prove their damages. So, for instance, they would have to show that they have some bills or invoices from having gone to a physician or a psychiatrist. But here, asking them to submit to a psychiatric exam, that is very intrusive. I agree with the plaintiffs that that would make it extremely intrusive. So clearly, the plaintiffs were distressed by the incident. Any family member is going to be distressed because their family member has been killed in a helicopter crash. But also, you can imagine that they would be distressed knowing that these pictures were out there. So I think as an alternative, what the judge could do is demand that the defendants in this case have their own psychiatrist come to testify to talk about whether those photos would be distressing.
Interesting. Now, Sue Ann, does the county have a point that they can't separate the harm of losing a lost one to that of these leaked photos? And what does that mean if they can't separate the two?
The county doesn't have a point. The county is doing too much. Obviously, they're trying to cover liability of one of their own employees that admittedly leaked the photos. So to me, this is something that should be stipulated to. I think we're all just generally civilians know that if you're in a situation where your loved one has passed away, seeing their images on TV before you even have the opportunity to identify them and deal with the grief, speak to your other family members is going to be distressing, much less for someone who lives their life in the public eye and is publicly losing two members of their family at the same time. So I just think LA County is doing too much. They can stipulate to it. I get it. Defense attorneys are going to defend, but this is too much.
Absolutely. I would tend to agree with you there. And in other top legal news, a West Coast judge rules in favor of two prominent journalists in the federal trial of Elizabeth Holmes. On Thursday, a judge sided in favor of John Carreyrou weeks after the defense added him to the witness list. Back in 2015, Carreyrou broke the Theranos fraud story that would be the catalyst for Holmes' charges. After that, Holmes' defense team added Carreyrou to the witness list, something the journalist's attorneys called a ruse so that he could not cover the trial. As a witness, Carreyrou could have faced an exclusion order, meaning a witness cannot be in the courtroom for other witness testimony, or a gag order, meaning a witness cannot discuss their testimony. On Thursday, Magistrate Judge Nathaniel Cousins ruled that Carreyrou should be considered an expert witness rather than a fact witness. That means Carreyrou can be present in the courtroom and report on the trial for his podcast. The same judge also denied a defense motion that would have required reporter Roger Parloff to hand over his reporter notes and audio clips. Holmes, the former CEO of now-defunct company Theranos, faces 12 counts of fraud for her time with the company. Holmes claimed Theranos would revolutionize blood testing, but later tests found many problems with the Theranos devices. When we come back, a surviving victim of the Kenosha shootings sues the city. How Gage Okrowski blames Kenosha, Wisconsin for allowing vigilantes to patrol the streets the night that he lost most of his bicep. Welcome back. Just weeks before the trial of accused Kenosha shooter Kyle Rittenhouse is set to begin, a shooting victim files a lawsuit against Wisconsin authorities, claiming they enabled deadly violence at the riots. In August 2020, Gage Groskowitz was shot and severely injured during the Kenosha unrest shootings. He lost 90% of his bicep after being shot. Now, Groskowitz has filed a lawsuit against the city, county, and several law enforcement officers, claiming that they supported the efforts of white nationalists that showed up at the protests. The rally began after the shooting of Jacob Blake, an unarmed black man who was shot by police. Authorities say 18-year-old Kyle Rittenhouse showed up at the rallies wielding a rifle. He shot and killed Anthony Hubbard and Joseph Rosenbaum in the shootings. Groskowitz was shot and severely injured, but survived. His lawsuit claims that authorities knew armed vigilantes planned to patrol the protests and welcomed their participation. The lawsuit says, quote, "It was not a mistake that Kyle Rittenhouse shot and killed 2 people and maimed a 3rd. It goes on to say that it was, quote, a natural consequence of the actions of the police department. The trial for Kyle Rittenhouse is set to begin with jury selection on November 1st. So, Ann, what facts would need to come out for this civil case for the plaintiff to win his claim, and do you think it's even possible?
Aside from the fact that I strongly think Kyle Rittenhouse should have been at home doing his homework, with respect to the case, I think that they're going to have to show that the police had a duty, obviously, and that the duty was breached. In terms of parts of the case that allege racial discrimination, saying that the police allowed white nationalists to do what they wanted to, but were being tougher on non-white nationalist protesters. I don't think he has standing there, but I think to demonstrate that somehow the police were working in conjunction or almost supporting Kyle Rittenhouse specifically, perhaps, allowing him to walk around with the gun. I mean, for goodness sakes, the gun is bigger than his body. They didn't need to see his ID to see that it's an underage kid walking around with a huge firearm. So if he walked by some police officers and got a pat on the back, then they would be in the game to show that the police kind of sanctioned or allowed the conduct. But shy of that, it's going to be very tough to show that there was a breach of the police's duty or the city's duty to protect citizens.
Absolutely. Now, Terry, how much of the verdict in Rittenhouse's case is going to affect this civil lawsuit? What do you think?
Well, theoretically, it really should have no effect, but realistically, Brian, it really will have a great deal of effect on the civil case. If he's found not guilty, there's an implication that the city's not responsible. So I think it would really help as far as the civil lawsuit's concerned.
Absolutely. And thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.